This micro talk is part of a mini-series on the FINRA Notice on private placements. We encourage you to review the entire mini-series available on our free writings and perspectives blog. Thank you. Hi, I'm Tim Nagy. I'm a partner in the DC office of Mayor Brown. Thank you for joining me today to talk about FINRA Regulatory Notice 2308, which deals with members' obligations when selling private placements. Private placements are non-public securities offerings that are exempt from registration with the SEC, typically under a Reg D safe harbor. FINRA Regulatory Notice 2308 updates and supplements prior guidance, including Notice 10-22, which dealt with obligations of broker-dealers to conduct reasonable investigations in Reg D offerings. FINRA felt this update was necessary in light of developments in the unregistered securities offering market and related regulatory framework since 2010, the latter being primarily the implementation of Reg BI. In the notice, though, FINRA also noted there was a significant increase in the notional value of unregistered securities offerings as compared to registered public offerings. Notice 2308 highlights a member's obligation when recommending a private placement to conduct a reasonable investigation. This will be the primary focus of our discussion. The notice also addresses certain additional obligations for members when selling private placements, including FINRA filing requirements under Rules 5122 and 5123, FINRA's communications with the public rules, Rule 2210, and FINRA's supervision rules. Importantly, the notice does not create new regulatory requirements or new interpretations of existing requirements, and it does not relieve firms of any existing obligations under the federal securities laws and regulations. Notice 2308 provides guidance on members' responsibility when recommending a private placement to perform a reasonable investigation under the care obligation of Reg BI. This same obligation exists under FINRA's suitability rule for non-retail and under the case law interpreting the anti-fraud provisions of the federal securities laws. What constitutes a reasonable investigation depends on the facts and circumstances, including the nature of the recommendation, the role of the broker in the transaction, its knowledge of and relationship to the issuer, and the size and stability of the issuer. Not surprisingly, more thorough investigation may be required for securities issued by smaller companies of recent origin, which includes many private placement issuers. As noted by FINRA, the presence of red flags should alert brokers to the need for further inquiry. I encourage you to review the notice in its entirety. I also encourage you to visit Mayor Brown's free writings and perspectives blog for additional information on this topic and other regulatory developments. Thank you for your time.